It's 10:30 on a Thursday night. You're headed home on the Kilpatrick Turnpike. A busted taillight the only reason you got pulled over. The officer walks up, runs your license, hands it back. Then he says, calm as anything, go ahead and hand me your phone. Most people comply without even thinking, and in doing so, they hand over 10 years of text, photos, location history, banking apps, and search history without a single warrant being signed. But here's the part that's even scarier. Most people watching this already have a setting turned on that could unlock their phone before they even say a word. I'll show you exactly what that setting is in a few minutes, and why turning it off tonight could matter more than anything else you do after watching this video. But before we get there, if you remember one thing from this entire video, remember this sentence: I do not consent to a search of my phone. Those 10 words can be the difference between protecting your privacy and handing police access to virtually your entire digital life. And almost everyone watching this thinks they already know the law on this. Most of them are wrong. Imagine this. You get stopped for a broken taillight. The officer doesn't find drugs. He doesn't find weapons. He doesn't even write you a ticket. 20 minutes later, he's building an entirely different criminal case against you. Not because of anything inside your car, but because of one decision. You unlocked your phone. I represented people in Oklahoma whose biggest mistake wasn't what was in their vehicle. It was believing they had no choice when an officer asked to see their phone. By the time they called me, the phone had become the centerpiece of the entire case. That's why this matters. Most people assume that if a cop can search your car during a traffic stop, they can search your phone too. That assumption will cost you. In 2014, the U.S. Supreme Court decided Riley versus California. 9 justices, 0 dissents. That's about as unanimous as the Supreme Court ever gets, and it applies in Oklahoma. The court looked at what a modern cell phone actually contains. Photos going back a decade, private text, emails, location tracking everywhere you've ever been, banking apps, medical information, search history. Think about it for a second. If I handed a complete stranger your unlocked phone for 10 minutes, what would they learn about you? Where you've been, who you talked to, pictures of your family, your financial apps, medical appointments, every late night Google search you've ever made. That's exactly why the Supreme Court said a phone isn't just another object sitting in your pocket. The justices wrote that searching a phone is more like searching your entire home than glancing in your glove box. The scale of personal information is just not comparable to a wallet or a set of keys. The ruling was clear. Police need a warrant to search a cell phone, not probable cause alone, not simply because an officer asked. A warrant reviewed and signed by a judge who has found sufficient reason to authorize a search of that specific phone. So if the law is this clear, why do so many people still end up giving police access to everything on their phone? Because officers don't usually start by demanding your phone. They ask for it. The law sounds simple. In real life, this is where almost everyone gets it wrong. Officers know about Riley v. California. They're trained on it. They know they generally need a warrant to search your phone. So instead of telling you to hand it over, they ask. And the questions often sound less like requests and more like commands. Just let me take a quick look. You don't have anything to hide, do you? Things will go a lot smoother if you cooperate. And my personal favorite, I can get a warrant anyway, so you might as well save us both some time. Those don't sound like questions. They sound like orders. None of those statements by themselves change your constitutional rights. In just a moment, I'm going to show you the phone setting I mentioned at the beginning, the one that can completely undermine everything we've talked about if you leave it turned on. Put yourself in that situation. It's dark, traffic is flying by, red and blue lights are flashing behind you, an officer is standing at your window. When someone with a badge says, "Hand me your phone," it doesn't feel like a request. It feels like an order. That's why so many people comply without ever realizing they have a choice. Here's the legal reality you need to understand. If you hand over your phone voluntarily, that is consent, and consent overrides the warrant requirement completely. You've potentially opened the door to years of personal information, text, photos, emails, location history, financial apps, social media, and much more. Whether particular evidence is ultimately admissible depends on the facts and the law, but you've made it much harder to challenge the search. I've represented people in Oklahoma whose traffic stop should have ended with a warning or a ticket. Instead, it became something much bigger because they believed they had no choice but to unlock their phone. No warrant ever saw it, no arrest at that moment. Just a driver who thought they had to comply. And by the time they were sitting in my office, we weren't talking about a traffic stop anymore. We were talking about everything officers had found after they gained access to that cell phone. Now, you know how the trap is built. So, how do you stop that from happening? Here's the one sentence that shuts it down. Keep it short, keep it calm. I do not consent to a search of my phone. That's it. One sentence. No speeches, no debates, no attitude. You do not need to explain why. You do not need to cite the Supreme Court. You do not need to argue the Fourth Amendment. No justification required and no apology. If they push back, and they often will, say it again. I'm not refusing to cooperate with the stop, but I do not consent to a search of my phone. Stay calm. Keep your hands visible. Do not raise your voice. Do not physically pull the phone away or try to hide it. Say those words clearly so there's no question about what you said, because everything is being recorded on that body cam or body mic. You want that footage, audio, to show a calm, composed person invoking their constitutional rights. That is exactly what you want the record to reflect if this ever ends up in front of a judge. If this encounter is ever reviewed later, you want the record to clearly reflect you did not consent to the search. At this point, most people think they're protecting themselves. But this is where almost everyone misses the biggest mistake of all, because your own phone may be working against you. Now, let's go back to what I told you at the beginning of this video. The setting that's probably turned on right now, the one that can completely change this encounter before you even say a single word. The officer says, "Unlock it for me." At this point, most people think they've done everything right. They stayed calm, they didn't argue, they clearly said, "I do not consent to a search of my phone." They believe they protected themselves. Maybe, maybe not, because your own phone may do the unlocking for you. And that is the mistake almost nobody sees coming. Here's why. If your phone is set to unlock with Face ID or your fingerprint, you've introduced a legal issue that courts around the country are still working through. Depending on the facts and the law in your jurisdiction, officers may attempt to use biometric features like Face ID or a fingerprint to unlock a phone. Courts have reached different conclusions about when that is permissible, and the law continues to evolve in this area. The important takeaway isn't to predict how every court will rule, it's to avoid putting yourself in that position if you don't have to. That's why many privacy and digital right advocates recommend relying on a strong password instead of biometrically unlocking when privacy is especially important. Here's something you can do today in less than 2 minutes. Use a strong passcode and know how to temporarily disable Face ID or fingerprint unlocking on your phone if you are ever concerned about protecting access to your device. The exact steps vary depending on your iPhone or Android model. It's a simple change that gives you more control over when your phone can be unlocked. Once biometric unlocking is disabled, your passcode, not your face or fingerprints, is generally required to unlock that device. From a practical standpoint, the device remains locked until the proper credentials are entered. Think about the difference. A fingerprint can be taken from you. A face can be pointed at a camera. A passcode exists only in your head. Read that again. A passcode exists only inside your head. That's one of the biggest reasons privacy advocates recommend using one. I'll give you a real example from my practice. I represented someone who was stopped for a routine traffic violation. No drugs, no weapons, nothing illegal was found during the stop itself, but he handed over his phone because he thought he had to. Within minutes, officers were scrolling through messages. Those messages led to more questions, more investigation, more evidence. By the time he called a lawyer, the phone had become the centerpiece of the case against him. And none of that started with the search warrant. It started with one decision made on the side of the road. One moment where he believed he did not have a choice. That's exactly why I wanted to make this video. That entire chain of events started with one decision made on the side of the road in the presence of the police. So what if the officer says, "I'm taking the phone anyway"? At that point, your goal changes. You're no longer trying to win an argument on the side of the road. You're protecting your legal position for later. Do not fight over the phone physically. Do not try and grab it back. Do not delete anything while the officer is still on scene. Those decisions can create entirely new legal problems that are far more serious than the traffic stop itself. What you do is state your position one more time, clearly for the camera, for the body mic. I do not consent to a search of my phone. Then, once the encounter is over and you're free to leave, document everything while it's still fresh in your memory. Officer name, badge number, the time, the location, and exactly what was said. Here's why that's so important. If officers search your phone without lawful authority, your attorney may be able to challenge that search in court. One possible remedy is suppression of the evidence, meaning a judge may prevent prosecutors from using any improperly obtained evidence from your phone. I've seen those motions dramatically change the course of a criminal case, but it only exists because the person clearly said no in the first place. That's why those 10 words matter so much. I do not consent to a search of my phone. One thing people are often surprised to learn is where these issues actually come up. Most people picture major drug investigations or high-profile criminal cases. That's usually not where this starts. It starts with ordinary police encounters, a traffic stop, a DUI checkpoint, a broken taillight on Memorial Road, a speeding ticket on I-35, a stop on the Creek Turnpike after work. Your phone often contains more personal information than your wallet, your glove box, and even your home office combined. Think about what is actually sitting inside that device. Text messages, photos, contacts, banking records, location history, social media accounts, years of information about your life. That's why protecting access to it matters so much. The same calm, direct approach applies whether they're asking about your phone, where you're coming from, or anything else during that stop. You're not being difficult, you're not arguing, you're not being suspicious, you're not escalating the situation. You are exercising a right that 9 Supreme Court justices said you have, unanimously, without question. One final thing. If an officer presents a valid search warrant for your phone, a warrant signed by a judge, and specifically naming your device, you comply. That is the law. That doesn't mean the warrant is unlimited. It has to describe what officers are authorized to look for. Whether a warrant is overly broad or otherwise defective is a legal issue for your attorney to evaluate. That legal fight belongs to your attorney, not to you on the side of the road. And do not assume an officer has a warrant because they say one is coming. Ask to see it. If a valid warrant is presented, comply peacefully and contact an attorney as soon as you can. It's being processed is not a warrant. Your refusal stands until that document exists. Before you click away, let me leave you with one final thought. Most people don't lose their privacy because they don't have rights. They lose it because they don't realize that they're allowed to exercise those rights. A burnt-out taillight, a routine traffic stop, one simple question, can I see your phone? Now you know that one decision in that moment can change everything that comes after. And if that day ever comes, I hope you'll remember these 10 words. I do not consent to a search of my phone. Now, if you think that's surprising, wait until you see what the law actually says about searching your vehicle. Most Oklahoma drivers get that wrong too. In that video, I break down exactly when police can search your car, when they can't, and the mistakes that cause people to accidentally give up their Fourth Amendment rights. If this video helped you, that's the one you should watch next, because these two topics go hand in hand. Link is on the screen. And if you're facing charges or believe your phone was searched unlawfully in Oklahoma, our contact information is in the description below. We'd be happy to review your situation. I'm curious about your experience. Have you ever had an officer ask to search your phone during a traffic stop? Did you know you could refuse consent? Let me know in the comments. I read every one of them, and your experience may help someone else avoid making the same mistake. I'll see you in the next video.